Welcome to another $4 million strategies. Today, I'm super excited to have our guest, Lisa Bothwell. She's an attorney from AMM Law. And today she's going to talk about something that's very important. If you're considering selling your business, here's some legal tips that you need to consider in this process. Lisa, welcome to the $4 million strategies. Tell us what we need to know.
Carl, thank you so much for having me. So if you're considering you're selling your business in the next few years, I'm going to be talking about if you're going to be entering into an asset purchase agreement rather than a stock sale agreement. So there's a few things that always come up. Intellectual property is always a topic. So first up, if you're considering selling your business, you should identify what intellectual property you have. Do you have any trademarks, software, inventions? Do you want all of that IP included, or do you want to exclude some items? For instance, I had a client that had a sentimental attachment to one trademark, so we made sure we excluded that from the deal. And then you also want to make sure, do you have all the rights to that IP? For instance, if you had employees working on any inventions, do you have a document that in writing states that the employee is assigning those rights over to the seller? Contracts. This is always another big thing that comes up. First of all, do you have signed agreements with customers, or do you just have purchase orders? If you have signed agreements, do you have copies of all those agreements with both signatures on them? It's a good idea to kind of locate all those now. Also, can you assign those agreements? If so, how can you assign those agreements? There's an assignment provision usually towards the bottom of the agreement that can tell you if you can just automatically transfer it in the instance of a sale, or if you in fact need to have the customer sign off on it. Another big thing that comes up with customers that I always tell my clients, if you have a few key customers that make up a larger percentage of your business, you don't necessarily need to disclose the names of those customers and exactly how much revenue you're getting from each of those customers early on in the process. You can maybe in the earlier stages just state customer A, B, or C. Or for instance, my top 5 customers make up this percentage of my revenue, and kind of give that information so the buyer can properly evaluate, but not necessarily give them a roadmap to how you're running your company. Another big thing that always comes up in questions are litigation. It is absolutely fine if you have litigation or if you have some potential claims. You just want to make sure you disclose it both in due diligence process and listed on the disclosure schedules. And I always recommend that you do that earlier in the due diligence process. That way the buyer and the seller can decide exactly how they want to handle that. If they want to increase the indemnification cap, if they want to ask for indemnification escrow. And another big thing that always comes up is corporate governance. You want to make sure that you have copies of your formation documents. That's the black binder, usually that some lawyer at some point gave you. If not, you can always request copies of your articles of incorporation or your certificate of formation. They're also going to be asking you for copies of your governing document, which is your shareholders agreement or your operating agreement. And another thing that's going to come up is they're going to want to have a good standing certificate. So you want to make sure that you're filing all the reports with the state that you're organized under, and you're filing all your taxes. I always tell my clients that selling your business is a full-time job on top of having a full-time job. The more you can organize and get things in order ahead of time, the easier the actual process will be. You also want to control how your employees find out that you're selling. And one of the ways employees start to suspect that something is up is if the owner starts asking for reports or documents that they normally don't ask for. So one way to kind of get around that is if you can approach one employee if you don't know how to pull certain reports or you're on a tight timetable, and you can ask them, to enter into a stay bonus agreement with you. That stay bonus agreement would have a confidentiality agreement, and it does not necessarily have to be for a large amount of money. I've seen them for $5,000 or $10,000, where the employee would kind of keep everything confidential, and they can help you with the process itself. Usually that is split over 2 payments, and you usually do one payment when they sign the agreement and one payment upon what would be the closing of the sale.
Lisa,
And I'm
that
at
is
411.
Yeah, no, you're perfect. Lisa, that is great 4 minutes of wisdom right now for anybody who's considering selling their business in the next 1 to 2 years. It's you want to make sure you're getting this stuff taken care of, because otherwise in due diligence, you're going to get eaten up and it's going to reduce the value of your business. But if you have everything prepared, it increases the value of your business. And that's what firms like AMM Law and Lisa help share with us today, is if you do it the right way, you can help increase the value of business. Lisa, thank you so much for being on $4 million Strategy.
Thank you, Carl.